afternoon, everyone. Welcome to the District of Columbia Court of Appeals. We have one case on this afternoon's calendar, the Union Market Neighbors versus the DC Zoning Commission, 17AA780. Mr. Theresa?
May it please the court. My name is Theresa. I represent the Union Market Neighbors. May I reserve 3 minutes of my time for rebuttal? I'm here today primarily to address the issue of standing and whether or not the Union Market Neighbors have standing. For various reasons, we believe that we do. Our members reside one block from the development, which will be a 1.3 million square foot development. So we have two members that live one block from the development on 5th and Florida, and the development is going to be on 6th and Florida. We believe that the injuries that we've asserted in the brief lie within the zone of interests meant to be protected by the zoning regulations and also the comprehensive plan.
Let me ask you a couple related questions. One way of thinking about this issue of standing is it's not simply a matter of how close do you live, but a matter of articulation. Tell us what your concrete injury is.
Correct.
And don't simply give us conclusory statements. Show us some facts. So would you address standing with those ideas in mind?
Right. So we believe that we have standing because we've asserted injuries regarding noise, pollution. These are concrete injuries and pretty predictable from the size of the development that's going to be coming, and also, of course, the proximity. And that raises an interesting question. We're here right now, and mostly because it's been asserted that our injuries are generalized grievances and not expressed with particularity, and that's where the written reports come into play and are so important, because now we're here before the court and we're having to articulate our injuries with particularity. And really that places the burden on the residents to say more than, oh, well, pollution is going to be a predictable injury from this project. Whereas if we had a written report from DOEE, we could say, well, there's a certain amount of cars that are going to be a part of this project. There's going to be particulate matter in the air. And so without these reports from DOEE, DHCD, it really puts us at a disadvantage when it comes to expressing our injuries with particularity when it's accused that we're just making generalized grievances. What we can say is that these injuries are a part of the zone of interest meant to be protected by the zoning regulations and also by the comprehensive plan.
If I follow your argument, it essentially would require us to go all the way back to step one and start over again?
In terms of
throw out the record, have a new hearing, insist that various agencies file more reports, and then you would think you would have a fair shot?
Absolutely. That's the only way that residents can have a fair shot before the zoning commission is if these mandatory written reports are placed on the record prior to a hearing for PUD, which is what the statute calls for, Title 11, 2407.3. It calls for mandatory reports from the Department of Housing and Community Development and also from the Department of Transportation and any other relevant agency.
At what stage does it call for those reports? At this stage? At the first phase of a PUD?
Well, it says if a hearing is granted, then these reports shall be gathered. And so I'm not sure if the courts have addressed that. I don't believe that they have. The zoning commission...
I'm sorry, you might have a hearing at the first stage and the second stage, right? I mean, the first stage is just talking about massing the land, right? And the noise and pollution, that sounds to me more like how things are constructed or are you talking about noise and pollution after the land is developed in the way that the plan projects?
Absolutely. We're talking about it after it's been developed and also during the development. It's important that that this happens in the first stage, because in the first stage is when you grant approval for the PUD and you have to weigh the adverse impacts versus the benefits of the project, and there's no way that this can be done without the mandatory
So you're
written
saying
reports.
that they weren't looking at the actual use? I mean, my understanding is you have this property that's currently being used right now for, warehouses and construction, or, fabrication of materials, right?
Correct.
It's not a residential area.
No.
And you're turning it into office space, some residential housing, and some retail, right? And it's all supposed to be LEED certified platinum or something. But that's supposed to be good for the environment. So as far as where you end up, I mean, presumably the area is not LEED certified as it exists right now in its undeveloped state.
Correct, and that's one report that is not on the record. There are reports from the Department of Housing and Community Development, which is actually a named report in the statute that is said to be gathered. And so when we're asked about expressing our injuries with displacement and with tax rate increases with particularity, it's very hard to do without a written report from the Department of Housing and Community Development.
Get your own report.
And
Hire some experts, have some knowledgeable people testify. Make your own record.
I suppose that that's something that we could do, but there is a statute that requires that requires the production of these reports. And even having to go do that would be an injury, because we're having to come out of our pocket when that's something that should be a public function.
Is that the kind of injury that the statute contemplates that would give you standing?
Well, I think that the statute contemplates impacts to projects. They say that if there's going to be a project, then you have to assess the adverse impacts of the project, and in doing so, you have to collect these written reports, and you're going to assess the impacts, and so the impacts can either be negative or positive. And the comprehensive plan and the way that's laid out lets you know that there's plenty of adverse impacts that can come from the proposing of these projects. They even contemplated in the statute 2403.8, where they, assume that there's going to be adverse impacts when you upzone on these projects. And so it's like they know that there's going to be injuries. It's just a matter of what kind of injuries they're going to be.
I have a procedural question for you. In this case and others, your clients have complained the Commission's focus is too narrow. This is just one PUD among many.
Correct.
And taken collectively, all those PUDs are going to have a huge impact.
Yes.
Is there a procedure before the Commission where you can move to consolidate all those PUD applications?
I'm not sure if the developer could do that with other developers and consolidate them. I know that there's one statute, the 2400.3, where they're supposed to do a comprehensive review. And, of course, we would think a comprehensive review would be everything that's planned for the area. I know that the small area plan attempts to address that, but they speak many times in vague terms. And so they'll say, we contemplate an increase in density for this area, but they're not going to articulate, 1.3 million square feet of, increased usage. And that's what the PUD process is for.
I have a question about the merits. One of your complaints is that the Commission did not address the concept of linkage.
Correct.
And your opponents have two responses. They say you didn't read the regulation correctly, it doesn't apply, and even if it did did apply, it's too soon. That would be addressed at stage 2. Do you have any responses to those arguments?
Well, I think unless you're contemplating the uses in the first part of the PUD, there's no way that you can approve the PUD, which requires a weighing of the adverse impacts and the benefits. So you can't get a handle on the benefits of a project unless you know what the uses are going to be. And so
that's an argument from logic, and I like logic. Do you have any legal authority that would support what you're saying?
I don't have any case law on the housing linkage statute. In addition, I would say when you look at the statute, they discuss matter of right. And there's nothing about a PUD that is matter of right. This is all something that's granted after a weighing process and something that happens through public input. And so we didn't read the statute that way. In any event, I mean, and we don't believe that it's ambiguous, but if it was ambiguous, it would be the zoning commission's duty to say what that statute means and make a finding, a conclusion of law on it, because it was raised as a contested issue.
Another question about the merits. One of your arguments seems to be the commission didn't work hard enough. But I read their very long order, and 5 to 6 pages of it address UMN's complaints and arguments. Why isn't that enough to fulfill their duty of weighing the benefits versus the adverse effects?
Well, we believe that they are mostly arbitrary findings that they're making, that they have a predetermined idea of approving this project, and without the reports, without even allowing parties to participate fully, like our party, the attorney at the time put in a notice saying that they were going to be unable to make it, and they denied party status based on the fact that the attorney wouldn't be there. But it's common practice to consult with attorneys about the scheduling. They could have granted party status and rescheduled the hearing to when the attorney would be available. So, I mean, in a project like this, it's almost unconscionable that...
Is that notice in the record?
Yes, it is in the record.
I don't remember reading this argument in your brief, though, that they violated our rights by not rescheduling the hearing?
We didn't raise that at the brief, but it is in the zoning record that the attorney put in a notice saying that they would not be there.
You seem to suggest in your brief that because your client was not granted party status, that you somehow missed out on an opportunity for input post-hearing at the points when the commission expressed that it was not satisfied yet with the application and directed the developers to go back and address some of the points, such as the moderate to low-income rental housing, and they then came back with adjustments. I wasn't sure I understood your argument, because I'm assuming that even without party status, you could have known of those developments. So what exactly is your argument on this point?
Well, I think what we were arguing was that without party status, we were unable to file a motion to reconsider on the points, because if you don't have party status, they don't allow you to file a motion to reconsider.
Explain that. Don't they have a docket that's publicly available?
They do, but if you file a motion to reconsider, they mostly deny it because you don't have party status. The only way they have to accept it is if you have party status. Otherwise, they have discretion.
Going back for a moment to standing and the injury your clients assert, am I correct that what's proposed as part of this PUD is building on 6th Street and also on the Gallaudet campus? Is that right?
I believe so.
And
yes.
your clients all live on 5th Street?
Yes. Mm-hmm.
I mean, I've driven past that area, and it just seems to me that's kind of a long way from where these buildings are going up. So convince me that they're close enough to have standing in this matter.
Again, it's very hard. Perhaps we should have hired some experts to really flesh this out, but I know, and I'm just speaking from common sense, if you have 1.3 million square feet of development, it's going to overflow into parking. There's going to be a lot more foot traffic. There's going to be pollution. There's going to be stress on the infrastructure surrounding the area. Emergency response times are going to be impacted. And
Well,
these are
there
things.
were reports, or at least responses. I'm not quite sure what constitutes the kind of report you've been talking about. But in reading the Zoning Commission decision, I saw that there had been input from the Fire and Emergency Medical Agency to the effect that the additional population of people in the area could be supported for those services. There is now an above-ground parking garage, and there will be underground parking if the development goes as proposed. There was consultation with Metro, and they can accommodate the number of additional people projected to be added to the community. So these things were taken into account. And I could see that even if you live on Fifth Street, you might be impacted by those things. But it seems that those were taken into account, and I'm having difficulty sort of figuring out why the Fifth Streeters' interest is any more particularized than just sort of a general grievance about not a lack of conformity with the comprehensive plan, if that's what you're arguing.
Well, some of the issues they did address. I don't know if it came through the required format of whether it came through the written agency reports, but I know for a fact one was not. They did not do a Department of Housing and Community Development report. And one of our clients claims injuries to tax rate increases, fear of displacement. She lives in the home, owns a home, and fears that tax rates are going to go up. And this would be a particularized injury from a development of this size, one block from her home. Like, we know that's going to impact and create an impact on housing values when the Zoning Commission is supposed to look out for the stabilization of housing values.
Could you speak to that a little more? Usually, when the tax rate goes up, that's the bad news. The good news is the value of the house you own has gone up too. So in the balance, why is that an injury to your clients?
Well, this particular client is handicapped, is on a fixed income. So even if the housing value does go up, that's a neighborhood that she wants to live in. That's a neighborhood that she's part of, and she doesn't want to be displaced. And displacement is something that is within the zone of interest per the comp plan.
Some of the neighbors, many of the neighbors, welcome this project. Why should your clients get to veto it?
I don't know if it's whether my clients get to veto it, but I feel like my clients definitely have been injured by the project, and they definitely deserve a fair process.
Okay. We'll give you a few minutes in rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors.
Good afternoon.
Phil Fiola for the interveners in this case. I'd just like to address the standing issue just really briefly. Notwithstanding what the petitioner just articulated, this court has identified specific things that must be pleaded in order to have standing before this court. And I don't need to repeat them to Your Honors, but there needs to be injury in fact, and it has to be alleged. And if you look through all of the filings that
Well, that's
were
if
made...
you're a plaintiff suing. That's if you're a plaintiff suing, but if you're in an administrative proceeding, right, where you're trying to intervene, are we so strict in this context to show injury in fact, right?
Absolutely not. But the zoning regulations do have a requirement that the person who applies must show a impact that's different and unique, distinctly different and unique than the general public.
Okay, and it doesn't seem like a stretch to say, I live a block away from 175,000 square feet of property that's going to be developed into multi-use office, retail, residential space, and a space where, it's kind of sleepy right now. That is going to be a real shot in the arm in that area of the neighborhood to say, I'm going to be affected one way or another.
It's absolutely not a stretch, but it has to be pleaded. Somebody has to tell the zoning commission what their injury is. And in the filings before the zoning commission, there was no such specificity. It was very general. It talks about the demand for better planning in the area. It talks about fundamental adverse impact. But it doesn't tie it back to the individual. And, in fact, because they did not come to the hearing, the zoning commission couldn't probe to find out, Mrs. Jones or Mr. Smith, what is your injury?
Let me give you a concrete example. I know you come down here frequently. Until about a month and a half ago, we lived next door to a construction zone. It's not a matter of theory to think that there would be noise and dust and disruption because we were so close to that construction. So why don't these folks have at least a decent complaint about noise and dust and disruption and impairment of their travel routes and things like that?
If they had pleaded that, I believe they would have gotten party standing at the zoning commission, but they didn't. Their pleadings were general. They submitted, I believe, 9 forms that were just check the box of what you feel was wrong with this, and it never tied back to what their injury in fact was.
So let's separate two questions that are pretty close. Party status and standing to be heard here on appeal. Do you think it was necessary for them to plead what you described before the commission in order to have standing to pursue this appeal?
No. No, the court has been very clear about that an aggrieved person need not be a party below at an administrative hearing.
So can we look to the more recent affidavits they've submitted trying to bolster their argument for standing?
I would submit that I'm not sure that would be appropriate since those affidavits were submitted almost a year after the record closed in this case. But even if you did, those complaints are almost even more general. One person complained that the family's pedestrian safety would be impacted because he relies on public services like library, schools, and parking, which, by the way, were not pleaded below to the zoning commission. Another one was concerned about the low-rise townhouse community that he lived in, but didn't say how it would be negatively impacted. And the third was concerned about the health impacts on her because of this development. Again, it didn't tie back to the development or the things that the zoning commission are empowered to evaluate and rule on. And as a matter of fact, the issue of the DHCD report that petitioner referenced in his argument just a few minutes ago didn't show up at all until their brief. It seems to me, if nothing else, the Howell case stands for the fact that only in very unusual circumstances would a claim made before this court be given any credence if it hadn't been pleaded below. And again, because they weren't there, they didn't articulate any of this, what their concerns are, to the zoning commission. And it seems like the agency should have the opportunity to hear what those complaints are.
When you say pleaded, do you mean it should have been highlighted or mentioned at least
Articulated.
In their request for party status?
Yeah, articulate. I'm sorry, articulate would have been a better word, Your Honor, not pleaded. That's correct.
But when? In the request for party status?
Or in their filings. Their filings were accepted by the commission, notwithstanding they weren't there. There was a 2-page filing they made that was accepted to the record. But they didn't tie those things together.
Mr. Theresa says that there were some mandatory written reports that were supposed to have been produced but weren't. Do you agree with that?
No, I do not, Your Honor. The requirement in the zoning regulations that the zoning regulation directs the Office of Planning to send the application, in this case a plan unit development application, to a variety of agencies, the HCD, the Department of Transportation, a list of agencies. There's no requirement that those agencies report back to the Zoning Commission on any of those elements. In the record, there is indication that the Fire Emergency Management Fire Department, I never get it all that right, did have conversations with the applicant, but they didn't file a report. There is information that the applicant met with the Department of the Environment and satisfied the Department of the Environment. This was through the Office of Planning's reports that were filed in the record. But not all the agencies responded. And there's no requirement that the Zoning Commission must wait for those agencies to respond.
A big concern, legitimately so, is the effect on property values, property taxes, so on and so forth. Is there a report that addresses those concerns? The small area plan that was mandated by the comprehensive plan, actually the upper northeast element of the comprehensive plan, section, to give you a site, 2.1.2 and action 2.1.a require the development of a small area plan for what then was called the Capital City Market. It's now called the Florida Market. That plan was done over a 2-year period by the Office of Planning with input from the agencies. We submitted the whole plan in our supplemental appendix. But that plan specifically talks about the kinds of things that the plan looked at as it went through it, in its own words, that they were to evaluate the existing infrastructure, the economic vitality and potential impacts of the plan in order to prepare it. That's on page 131 of our supplemental appendix, which is right out of the plan. And it looked at the building conditions, the circulation, the economic growth, the economic pressures, the traffic and safety, environmental impacts, and neighboring communities and zoning as part of that plan. The plan is a couple hundred pages long. It went through 2 years of public review. It was approved by the council in 2009, and as the court has told us in this past spring, in the Barry Farms case, the Zoning Commission has to take this into consideration. It is not unreasonable for the Zoning Commission to take the results of a plan like this and rely on work that has been done with regard to things like the stabilization of plan. But even more to the point, this is the first stage of a two-stage PUD, and as the court said in, I think it was Foggy Bottom versus Zoning Commission, the approval of the first stage PUD does nothing more than give an applicant the right to continue the zoning process. And the commission in this case recognized that, and there's a condition in the zoning order, it's condition 9A, I'll get the exact site, but it says when the applicant files for each phase, each second stage PUD, it will provide an impact analysis of anything that we haven't already discussed, which means pretty much anything. So there's an opportunity for the petitioners to participate and see those kinds of analysis that are done in the second stage. When the project has more definition than just a site plan and a massing, and as the Zoning Commission order says in finding of fact number 36, the applicant was only asking here for a site plan and a massing. It wasn't asking for the kind of level of detail that's needed to get a building permit to go to the next step. So we're only halfway through the zoning process. In practical terms, what does first stage approval allow you to do in terms of preparing the site, knocking things down and closing alleys? And can you do any of that until you get second stage approval?
Not under the zoning. There are certain things you could do as a matter of right on this property. For example, there would be no prohibition to tear down the warehouses that are there or to plant grass where there's surface parking. But in order to implement this PUD, there's absolutely nothing. As the court said in Foggy Bottom, there's merely the permission to continue the zoning process. It doesn't give you a right to build anything or do anything under that development. So we believe that a combination of reliance on the small area plan was certainly something that within the Zoning Commission's authority to do with regard to many of the issues that have been raised, but even more importantly, the Zoning Commission has recognized that there's going to have to be more analysis and more study of the impacts, and has directed the applicant as a condition of this order to provide those for when they come back the next time for a building or buildings. So we think that the Zoning Commission didn't act inappropriately by deferring the action on some of these impacts that, for example, the McMillan Court has asked the Zoning Commission to look at. We're just not there yet. And at some point we will, and hopefully we won't be back before the court arguing it, but it's always fun to be here.
So if we ever get to the second stage and UMN says, what about housing linkage? You're not going to stand up and say, too late, should have done that at the first stage?
No, as long as they do it on the record in the second stage and don't just plead it to the court, I think it's reasonable to address that issue at the Zoning Commission. And I might say about the housing linkage issue, because, Your Honor, you picked that up. There is no requirement for housing linkage pursuant to 2404 when the proposed office gross floor area is not greater than that would permit it as a matter of right under the zone that's contemplated in the PUD. It's pretty clear.
I understand your argument from plain language. Do you have a case that says that?
No. The plain language is so plain, I don't think it needs to be articulated in cases. And in fact, the housing linkage law is relatively new, so I don't think it's been tested. But on the second piece of that, I'm not even sure that it rises to the level of a material contested issue. And if you think about it, this issue was raised in appendix page 109. It's one sentence in a record that's about 1,200 pages long by the petitioner. I'm not sure it rises to the level of a material issue, especially when that regulation doesn't apply to this case. Otherwise, we'd be asking the Zoning Commission, well, what about antennas? They have a chapter on antennas. They have a chapter on retaining walls. They have a chapter on roof structures. If they had to answer every issue that's not applicable to an application, these 50-page orders would be 200 pages. So in our opinion, it doesn't apply, and it wasn't a material contested issue. And again, had the petitioner showed up and made some comments about it, maybe the Zoning Commission could have directed them to the language and explain why.
Let me ask you some pointed questions about that.
Certainly.
It would have been a good idea to show up, but with a project of this size, there's no party in opposition except UMN volunteering to oppose. They're not people from West Virginia objecting to this. They're close by neighbors. I have a two-part question. Wouldn't it be sensible for your clients not to oppose party status? And wouldn't it be prudent for the Commission to grant them party status provided they show up?
I think it would have been prudent for the Zoning Commission to grant them party status had they been there to explain to the Commission those issues. If you look at the Tiber Island Co-op case, which is the case most recently that the court has considered party status, in that case the petitioner was denied party status, but the petitioner, according to the reported case, had a discussion, argument with the Zoning Commission as to whether they should be granted party status or not. They were turned down, but they stayed and testified. They were given extra time. They even presented to the Zoning Commission alternatives for the applicant to consider as opposed to the case at bar. So the Zoning Commission had something to hold on to in terms of the substance. But it's very hard in the abstract when you get these nine forms with just blocks checked. Some of the comments on it were things like, we want more homes for the homeless. Well, everybody wants more homes for the homeless, I think, but it didn't apply to this project. You know, those forms listed 6 different zoning cases that the UMN were opposed to, but didn't specify to what was the problem with this zoning case. So I don't think it was inappropriate for the zoning commission to deny party status in this case because they couldn't query. And in fact,
what about counsel's argument that the lawyer actually filed something saying, I can't appear?
But he didn't file a motion to continue. He didn't ask any postponement. He just said, I'm sorry, I can't be there, and submitted his 2 pages in writing. It seems like it should at least plead the request, and then maybe we would be talking about whether or not it was denied appropriately or not. But he didn't ask that. So it seems like it would be beneficial to everybody, including the zoning commission, had opponents participated in the hearing. And this was not
next time you're not going to oppose their application?
Well, we opposed it mostly because it came in so late, and with the supplemental filing the night of the hearing, they're supposed to do 14 days in advance. They did a very simple one first and it made the deadline, but then came in with more information at the night of the hearing. But this was not a surprise PUD application. It had been in the community. 2 ANCs supported it after many public meetings and discussions. After, I think it was filed, and it took 17 months to get to a hearing. So it wasn't a hidden, behind-the-scenes kind of an approval. The Zoning Commission gave proper notice and invited people to participate. And I think it is important, Your Honor, that the official organizations for representing this community, the Advisory Neighborhood Commission supported it, as did the adjacent Advisory Neighborhood Commission. So,
the major reason why you need the flexibility that a PUD offers is what? Is it that you're in a commercial zone and you want to do residential housing? Is that the biggest part of it?
It is in an industrial zone. And industrial zones do not allow residential per se. They're prohibited. So you can't put a single-family house or an apartment building in an industrial zone. It was CM1 zoning at the time. It needed to be changed to a zone that allows residential and mixed use. And it's also was called for in the small area plan to change the character of this area from a kind of a dilapidated warehouse surface parking lot area into something that would be better served pursuant to the comprehensive plan and the upper northeast element, which call for this small area plan. So the PUD application gives our client the opportunity to change the zoning to allow residential and other uses, but it gives the zoning commission and the city absolute control as to how tall the building is going to be, what color the brick's going to be at the end of the day, and because with the PUD approval, if it's approved, there is a covenant entered in the land record that basically requires the project that was approved to be built. So it works on both sides. The city and the neighbors have the right to ensure that what was proposed gets built. It's not a bait and switch. And the developer has the right to ask for some flexibility in that process. So,
thank you, counsel.
My pleasure, Your Honors. Thank you.
Counsel, you'd asked for 3 minutes. We'll give you 3.
Yes. Thank you. So really quickly, I want to speak to this issue of the second phase and them addressing the housing linkage requirement in the second phase. The order very clearly states on page 43, paragraph 104, that no additional benefits and amenities shall be expected when the second stage act is processed. And so...
Isn't that a separate question, though? That's not phrased in terms of housing linkage. It's balancing of benefits and amenities versus adverse effects.
Well, I would say that it's related because you can't make that assessment without knowing what the uses are. And so the fact that they said that this is what the uses are going to be and there's not going to be anything additional for the second stage says that there is not that opportunity to come back and address the second stage, and nor will they be doing anything different from what they've done in the first part of the project.
As I understand it, and I'm not sure I do, once these buildings are built, we don't yet know how much of them will be devoted to offices and how much will be devoted to residences. Depends in part on the market. So we can't know the answer to housing linkage, can we? Until we know how much is office and commercial and how much is residential.
Well, they can definitely put forward a plan. I've seen developments where they know what they're producing. For instance, they're doing something at Reunion Square right now where they know what the office space is going to be and what they plan on providing. I also want to say something about the NOMA, the plan where Gallaudet has argued that this is stuff that's kind of baked in the small area plan and therefore doesn't need comprehensive reports or planning reports. The NOMA plan actually states that there were no impact studies done and that would be done, that there would be a detailed review at each project to do those impact studies. And also, I kind of want to push back a little bit on Gallaudet's argument that we never raised the issue of DHCD reports. We raised the issue of a comprehensive public review, and these are things that are required by the Zoning Commission.
But that's so general. Did you ever say, what about this report from the Housing and Community Development Department?
I'm not sure if that was explicitly stated on the record. We did cite to the statute for a comprehensive public review. And in any event, this is something that they're required to do. And I don't know if it's the public's job to remind them of their fundamental duties as zoning commissioners. This is something that we were injured by. The fact that they didn't do it, and so we're bringing it before the Court of Appeals.
But
okay, go ahead.
I used to make my living as an advocate. I hope that if I felt like you do, I would have showed up at the hearing and said, time out, folks. We're not ready for this hearing. You haven't got the records you're obliged to consider. Let's step back a bit and get what we need before we go any further. You didn't do that.
That would be the ideal situation. Council at the time did put in a note stating that they would be unable to make it. They even submitted questions to be placed onto the record. Again, this is a group. This is one of almost 18 projects, and this isn't these people's full-time jobs to do this. Counsel for Gallaudet. This is their one case or two cases or whatever. This is where these people live. It's not their job. There are so many projects going on, and they do the best that they can keeping up with it.
Okay. Thank you. We appreciate your argument. Mr. Paola, thank you for yours. The case will be submitted and the court will stand adjourned.